We will
Good afternoon,
start.
sir.
Yeah, good afternoon. I would request to participant to please switch on your videos so that we will have interactive sessions. Instead, one-way traffic, it should be both-way traffic. So we will have interactive session. I hope most of you have finished your lunch, or somebody might be taking nap after lunch, because time after 2 o'clock after lunch, people feel laziness. That's why.
No, don't worry. No
Okay.
one is busy. Everyone is serious.
I will tell you the reason of the laziness also. First, we will start the some important judgment and recent case laws. Okay. So I'll take one by one. There is no PPT. I have just collected recent cases and some important cases which are very important. Just And one thing more I would like to say, that it is very difficult to remember all cases in details. Being an IP, being an IP, we are supposed to know the basic concept of the case law instead of going into facts, issues, decision, all these things. You will not remember. But if we focus on only particular things, that in this case this was happened, then you will remember, and whenever you will take the charge of liquidator IP whatsoever, then you will remember, yes, this was the issue and this was the decision, and then you will execute the CIRP or liquidation process accordingly. It will very helpful. So I have taken some of the cases, case notes, and thereafter some of the cases in details. Just a moment. See, before starting, I ask one question, whether section 10A notice can be shifted. Section 10A, you know what is section 10A of the IBC?
Yes,
That's
yes, of course. No.
COVID
yes, Mr.
issues.
Rao. Yeah, please.
This is regarding COVID default during
Yes,
COVID.
very true, very true. So during the COVID period, if any default has occurred, then CRP cannot commence. So what happened? In one case, the creditor shifted this period and issued the notice of default. I'll just share the head notes of this, then you will, just a moment. Date of default occurring within the prohibited period under section 10A of the IBC can't be shifted by sending notice after prohibited period for the same dates. The NCLT Mumbai bench, in the case of Mr. K.R. Saji Kumar, the bench of Mr. K.R. Saji Kumar and so and so held that the default occurring within the prohibited period cannot be shifted merely because a notice of for payment is issued again after the end of the such period. REC Limited Financial Creditor filed a petition. REC is a Navratna company, and their legal department issued notice, section 7, against the Global Metal Energy Private Limited, the CD. The petition was filed for claiming an amount of just a moment. I'll just explain. To the tune of rupees 47.09 crores, the amount was advanced to the CD in 2015 for setting up 10 megawatt wind power project. Thereafter, account of the CD was classified as NPA in 2018, which was later regularized. When the CD defaulted, the account was again classified as NPA on 31st March 2021. The financial creditor sent multiple demand notice, but no response was given by the CD, despite the debt being acknowledged. So in this case, as I briefed you, that default occurred during the COVID period, but notice of default issued later on. So NCLT held that no, you cannot shift the default period. This is the main crux of the judgment. That's why I have taken this. Still, I am seeing most of the videos are off, and this might be reason of like feeling laziness or after lunch. So I would also ask one practical question. If anybody knows why after lunch or after 1 p.m. we feel laziness or we start napping. Some people get take napping.
Age
Can
factor.
anybody say? Yeah.
That is because of the age factor.
Acha, anybody else? It's very interesting question. I'll let you know. You will.
Sir, because of heavy lunch.
Okay. Anybody else? Today you will learn very practical things which you have never learned in your life. I'll tell you. Even I learned recently when I took one session of yoga, very important session. Can anybody know? Can anybody tell me about this circadian rhythm? I'll just giving you clue. Circadian rhythm. Jain Saab,
Is it monotonous speech or something like that?
no. Please don't
Just
guess unless you know. See, we know IBC, we know law. Everybody know IBC, laws, company law, accounting, financial, everything. We don't know our body clock. We know the clock. It starts from 000 midnight till midnight. So 24 hours we know, but we don't know we know the outer clock, but we don't know our body clock. Have you heard about the body clock? Biological clock? Circadian rhythm is also called biological clock. Would you like to know about this, Mr. Rao? एज फैक्टर सबके साथ नहीं होता, सबके इवन यंग पीपल जो आपका टीनेजर्स है 22, 23, 13 years, they also feel the same kind of like after 1 p.m.
Yes, sir.
laziness.
Tell me.
Huh.
Tell us.
I'll share this circadian rhythm clock. Just hold on. This is very interesting. See, this is our biological clock. आपके पास जो घड़ी है हाथ में लगाते हैं, मोबाइल में लगाते हैं, दैट इज डिफरेंट. ये घड़ी हमारा बॉडी के अंदर फिट है. आपको किसी ने नहीं बताया होगा. आई टेल यू व्हाट इज सर्केडियम रिदम. सी हियर मिडनाइट 000. I'll start from here. Otherwise, I'll start from here. 12 noon. I'll start from here. 12 noon. Is this visible? हाँ जी, दिख रहा है ये घड़ी ठीक से?
दिख रहा है, दिख रहा
Yeah,
है.
yeah.
ठीक है. So,
Visible, sir.
हाँ, it is 12 noon. After 12 noon, what happened? Our body like response, body's rhythm. 12:30, 12, 1 p.m., 2:30, best coordination. So between 12 noon to 2:30, there is some laziness. I'll share another slides also. Fastest reaction time 3:30. Greatest cardiovascular efficiency and muscle strength. So most of the people join gym and do the workout after 5 p.m. because this time cardiovascular having most efficiency. Then come to 6 p.m. highest blood pressure. जिनको बीपी का प्रॉब्लम होगा, you will feel even if you have doctor's prescription, he must have written in the prescription take BP tablet after 6 p.m. Why? Because BP आपका हाई होता है after 6 p.m. Am I right? आपका डॉक्टर ने लिखा होगा किसी को बीपी का प्रॉब्लम हो. Then highest body temperature 6:30. अगर किसी को सर्वाइकल viral fever, if you are feeling some viral fever or some fever, then after 6:30 you will have more temperature. Thereafter again you will take crocin. Then come to here. Melatonin secretion start. This is very, very important. Today, just a moment. I'll just stop this sharing. Today, what we do, we never bother about the watch. We never bother about our body. We just see we have workload, we have this thing, we will perform this work, we will finish this work by midnight, by 11 p.m. But we do not care about our body. And that is the reason we invite diseases, multiple diseases, obesity, diabetes, heart patients, etc., etc., and insomnia, and then depression. So why? So why, if you will see earlier, before 20 years, 30 years, before digital age, most of the people used to sleep after 9:30, 10, or maximum 10:30. But now they have extended their time and they are like limitless. Somebody is sleeping after 11 p.m., 12 midnight, 1 a.m. like that. So this is very harmful. You will say why it is harmful? Why we should follow the this natural clock or body clock? I'll tell you. See, 9 p.m. 21.00 hours. Melatonin secretion start. Can anybody say what is melatonin? हाँ जी, ये नया आईबीसी लॉ है. थोड़ा सा मुस्कुरा दीजिए. It will increase your it is very healthy for your heart also. हाँ.
It will increase melatonin.
Yeah, it will increase melatonin in your body. See, melatonin secretion starts at 9 p.m. and thereafter it increases gradually. And at 12:30, sorry, 10:30, bowel movements suppressed. And then midnight, these all periods are melatonin secretion, deepest sleep at 2 a.m. ज्यादातर चोरी, robbery, burglary starts after 2 a.m. between 2 to 4. Have you seen? क्योंकि डीपेस्ट स्लीप होता है 2 a.m. पे. ओके. एंड देयर आफ्टर secretion get stop after it reduces after 3 a.m. So melatonin, I'll tell you what is the function of melatonin. See, everybody should know. I am just telling you, you should also teach all these things. You should also tell to your family members, your friends, why we should follow the body clock. So melatonin here, it start reduces after 3 a.m. and lowest body temperature 4:30 a.m. Now you will see in the winter season, most of the cardiac arrest take place after 4 a.m. So body temperature get reduced. Even during summer season, these scientists or even doctors also advise, please switch off your air conditioner because our body temperature get reduced. So after 4 a.m., no AC, no air condition, even in summer season. Thereafter 6 a.m. sharpest blood pressure rise. The sharpest blood pressure rises 6 a.m. and 7:30 p.m. melatonin secretion stop. Bowel movement, highest testosterone secretion, highest alertness 10 a.m. आप सुबह जब जाते हैं ऑफिस के लिए, your alertness starts after 9:30. Highest alertness 10 a.m. and thereafter 12, and thereafter best coordination. So I'll just come to the first floor. Deepest sleep, then lowest body temperature, sharpest blood pressure, melatonin secretion stop, highest.
But I didn't get what is melatonin.
That I will tell you. That is the highlights of these stages. Just a moment. 12, 12, 6. यहाँ आते हैं 6 हाईएस्ट alertness, बेस्ट कोऑर्डिनेशन, फास्टेस्ट रिएक्शन टाइम. See, actually, I think one slides I am missing. What happened after 12 noon? What I started this session that after this 1 p.m. we feel laziness because our after meal our body temperature also get reduced. पेट में थोड़ा सा कुछ होने से वी ऑल्सो फील सम लेजीनेस. तो ये है ना, एक्चुअल में दिस इज द बिकॉज ऑफ द बॉडी क्लॉक, आवर बायोलॉजिकल क्लॉक. वी फील लेजीनेस बिटवीन 1 p.m. to 2:30 p.m. और देन आवर अगेन 3:30 में आपका फास्टेस्ट रिएक्शन टाइम होगा. फिर से आप अलर्टनेस यू विल अगेन, जो आपने वीडियो ऑन ऑफ कर रखा है बहुत से लोग, अब 3:30 बजे हो सकता है ऑन कर ले. तो circadian rhythm are physical, mental, and behavioral changes that follows a 24-hour cycle. Typical circadian rhythm leads to high energy during the middle of the day, 10 a.m. to 1 p.m. and afternoon slump. Circadian rhythm gets slump afternoon. At night, circadian rhythm causes the hormone melatonin to rise, making a person sleepy. अब हम लोग क्या करते हैं, इवन इफ feel sleepy, we avoid it because of work, because of XYZ reason, because of mobile, laptop, whatsoever. Now come to brain, melatonin. This is our melatonin synthesis. This is our pineal gland, pituitary gland, यहाँ हमारा सेंटर में होता है. ओके, एंड देन इनहिबिशन, स्टिमुलेशन, मेलाटोनिन सेक्रेशन यहाँ से होता है. दिस इज द केमिकल लाइक डोपामीन, एंडोर्फिन. हाँ, ये सारा जो हमारा ये सब सेक्रेशन होता है अपने ब्रेन से. मिड जो पिनियल ग्लैंड है या पिट्यूटरी ग्लैंड है, ये मेलाटोनिन इज ए केमिकल, ए हार्मोन्स which releases, which secretion starts after 9 p.m. and which thereafter we feel sleepy. So ये इसको अगर हम अवॉइड करेंगे तो हमारा स्लीपिंग डिसऑर्डर, इंसोम्निया, thereafter depression, anxiety, angriness, like all these things will come. So we should not avoid this thing, that whenever like after 9:30 10 p.m. we should go for sleep unless there is some very very urgent work. New baby born 2 months 12 से 18 घंटा, 12 to 18 hours he gets a infant. This is the timing of sleeping. How much a person?
So, Mr. Jain, in fact, what happens in case of infants,
Yeah.
they sleep most of the day and they keep the parents also awake during the midnight.
Yes,
So,
this
what
is
is
the,
the melatonin effect in their cases?
हाँ, उनका बॉडी में मेलाटोनिन ज्यादा होता है और उस समय का वो एज इस टाइप का होता है, सो दैट कि वो उनको उनका जो ग्रोथ भी होता है, दे ग्रो ड्यूरिंग दी नाइट. जब जितना सोते हैं उतना ज्यादा उनका ग्रोथ होता है.
No, but night they mostly infants keep awake. They keep awake and keep parents also awake because these infants keep sleeping the whole day.
Yes, it happens.
You
So
must have
that,
experienced this also.
हाँ, तो वो होता है बिकॉज, तो देन दे इन्फेंट गेट स्लीप इन डे टाइम मोस्ट ऑफ द, इन द इवनिंग टाइम, डे
Even
टाइम.
if we go and sleep whole day, and then in the night, melatonin will not be of any use
Yes,
actually.
and see here the number of hours, here it is not related with this melatonin. It is just telling the number of hours a person sleep. Newborn 12 to 18 hours, infant 14 to 15 hours, like that, and adult 7 to 9 hours. This is the maximum time. Sleeping disorder जो हमारा होता है, कई लोग को होगा. इज देयर एनीबॉडी फीलिंग स्लीपिंग डिसऑर्डर, कि आप गए, आपको नींद नहीं आ रही है, 12 बजे गए, 1 बजे गए, ऐसा? तो इसका रीजन यही है कि यू आर अवॉइडिंग दिस स्लीपिंग टाइम. irregular sleep, wake rhythm, free running time. So is this clear? Circadian rhythm clock and melatonin. This is the new case law for everybody. It is not related with only IPs, but we should know. Being a human being, we should know. Just a moment. Nidra circadian, read circadian. Okay. I have also done some research on brain anatomy, how our brain works. We will discuss in subsequent session. Now let us come to case laws. So we have discussed first case laws regarding section 10A. Now come to resolution plan. This is the judgment of Appellate Tribunal Principal Bench, New Delhi. I'll come to the only main point of this case. There were 3 CDs. Resolution plan was submitted. Resolution plan was approved by the COC, and thereafter RP also did all due diligence work like as 29A due diligence, etc. And thereafter, I'll come to the direct concluding part here. So this appeal has been filed by the unsuccessful resolution applicant. Just a moment. And in this judgment, Honorable Supreme Court citation of Honorable Supreme Court judgment was also taken up. In this case, JP Supreme Court has again reiterated that adjudicating authority has limited jurisdiction in the matter of approval of resolution plan. To put in nutshell, the AA has limited jurisdiction in the matter of approval of resolution plan, which is well defined and just a moment. Circumscribed by section 30 subsection 2 section 31 of the code, read with parameters delineated by this code. In the decision above referred, the jurisdiction of appellate authority is also circumscribed by the limited grounds of appeal provided in section 61 of the code. The adjudicating process concerning a resolution plan under IBC, there is no scope of What happened? This AA interfered in the resolution plan, and he raised some commercial aspects. And thereafter, this Appellate Tribunal has cited this judgment of Honorable Supreme Court regarding the commercial aspects of the decision of the COC, and there is no scope for substituting any commercial term of the resolution plan approved by the COC within its limited jurisdiction. If the AA or AA appellate authority, as the case may be, would find any shortcoming in the resolution plan vis-a-vis as specified parameter, it would only send the resolution plan back to the COC for resubmission after satisfying the parameters delineated by the code and exposited by this code. We answer the question as follows. SRA was eligible to submit the resolution plan as per clause so-and-so, invitation for EOI, and the net worth and turnover of the promoter, Mr. So-and-so, could be included in for the purpose of net worth for a group. It being entity within the meaning of clause so and so. Invitation for expression. In the foregoing discussion, we have considered the submission of appellant alleging material irregularities in the process adopting by the RP. We have already found that challenge mechanism as well as negotiation conducted by the RP is in accordance with the CRP process, CRP regulation and process note in evaluation the eligibility criteria of the SRA. Also, there is no irregularities committed by the RP. So what RP did the complete due diligence of section 29A regarding the eligibility. Despite so, unsuccessful resolution applicant filed this appeal and alleging made several allegations against the RP that he did not comply with the comply with the 29A, etc. We thus do not find any tenable ground raised within the meaning of section 61 to interfere with the order approving the resolution plan. The question number 4 is answered accordingly. In view of the foregoing discussion and conclusion, we do not find any ground to interfere in the order of so and so appeal, and appeal get dismissed. So in nutshell, if
What is the question of law framed by NCLAT in this case?
see here the allegation was made against the RP that he did not complete his due diligence. Number one, his resolution plan was not entertained despite of his eligibility. His resolution plan was not entertained because he was not eligible. That's why his resolution plan was not entertained by the RP. So first authority, I should not say authority, first person who can check the resolution plan about whether he meets the criteria of 29A or not, IBC or not, is the RP or IRP. If he said no, this PRA, prospective resolution applicant, is not meeting the criteria, then he straightforward he can reject. So first, because COC is not the professional, they are not the IP, they are not aware about the IBC law. So it is the IRP or RP who has to conduct all these due diligence. Second, balance sheet. See here, suppose a person issues notice under section 8 regarding the debt, regarding the default regarding the default of the dues amount. In this case, the person says, no, I am not liable to pay anything, but his balance sheet is showing X amount is due and payable to the supplier. Is it admissible whether his acknowledgement of debt in the balance sheet is will be treated as non-disputed debts, Mr. Rao?
Yes, of course. Once the debt is acknowledged in the balance sheet, then a company cannot run away from it.
Yeah, similar. Yeah, same thing was happened in this case. In this case, Vidya Sagar Prasad versus UCO Bank, 22nd October 2024. I am just coming to the operative part of this judgment. By the present appeal, the suspended director of the corporate debtor SL the order of the NCLAT affirming the order of the AA to admitting the application under section 7 of the initiating of corporate CRP 4 proceeding against the CD. The undisputed fact before us are the CD now represented by IRP availed loan and credit facilities from one NCLAT number so and so into Maharsa. So this is the loan related to loan amount Now, both these factors acknowledge the debts balance sheet as well as in the OTS proposal have been considered by the NCLAT while dismissing the appeal. The relevant portion of the NCLAT finding after the considering the balance sheet entries and OTS. See, OTS was also happened, balance sheet was also acknowledging, everything was showing. So NCLAT dismissed the appeal against the, uh, uh, it was filed by the other party, not by against, sorry, it was filed by the CD that the company should not go into CRP process. The company's balance sheet is prepared in the statutory format as per Schedule 3rd of the Companies Act 2013, which does not provide for giving the specific name of every secured and unsecured creditor. What happened in balance sheet? Usually we mention suppose 10 crores as a secured creditor or unsecured creditor, but we do not mention the name of the creditors. So in this case, they have challenged that their name is not showing in the balance sheet, so we should not be admitted. The CD should not go into CRP. But here in this judgment, it says that even if the name is not mentioned in the balance sheet, but amount is reflecting accumulated debts, still it is acknowledgement of the debts. It is further observed that the CD has not denied that there are no outstanding dues to the UCO Bank. A perusal of extract of the register of charges submitted with the ROC at serial number so and so 3 shows that the charge of rupees 175 crores created by the CD has not been satisfied and remain outstanding. In the instant case, we also find that the CD issued a letter dated 7th June 2016, wherein it has given OTS proposal based on the ratio of the judgment of Honorable Supreme Court in the case of Lakshmi Ratan Cotton Mills Limited, Cotton Mills Company Limited, and further reiterated in the Dena Bank case that there is an acknowledgement of subsisting liability of the CD. However, it may not necessarily specify the exact nature of the liability, but it indicates the jural relation between the parties, and in any event, the same can also be derived by implication. Further, the said letter is not without prejudice basis and therefore amount to an unequivocal acknowledgement of liability of the CD. A reading of the documents above reveals that the CD has acknowledged subsisting liability to attract the provisions of Section 18 of the Limitation Act. Having examined the matter in details, we are of the opinion that the findings arrived at by the AA and enclave are correct in law and facts. We find no merits in the appeal. Civil appeal number so and so is dismissed accordingly. So here the nutshell of this case is that even the balance sheet does not classify the creditor or does not name the creditors in accumulated amount of debts. Still they are liable because it has also been proved through the ancillary evidence or corroborated circumstances also, that the CD owes X amount to the UCO Bank. Even if their complete this classification is not mentioned, the CD is liable to be admitted for CIRP. Now I'll take next judgment. This is very important and very interesting judgment. This is a bit old but important. This case law is a bit old but it is important. This is the contempt proceeding and every IP must know what is the contempt, and how it take place. That's why I have taken this judgment. This is old, but this is very important. This is the Manoj Kumar Daga. He is the suspended management, and versus OC, IRP, Shikhar Jain. This appeal was filed by the suspended management regarding the violation of moratorium and contempt proceeding against the suspended management. The application for CRP was admitted under Section 9 before AA Cuttack bench. CD, which the application came to admitted by the impugned order dated 27 September 2019, and moratorium under Section 14 was declared by the AA. So, commencement of CRP is 27 September 2019. Against the order of admission under section, present appeal came to be filed by the appellant, Mr. Manoj Kumar Daga, a director of the company. When the appeal came up before so notice was issued to the respondent operation. In the meantime, IRP will not constitute. The interim order was there that IRP will not constitute the COC. However, the interim order will ensure that the company remains going concern. So this is the standard order which you have seen in many cases, that IRP will continue, will do all efforts for making the CD as a going concern, but he will not constitute the COC. But in this case, the COC was already constituted. The matter came up before the Ashwini Ko advocate so. The financial creditor submitted that the COC was constituted prior to 23rd October 19, because before passing the stay order, the COC was already constituted. The counsel for the RP also took the same plea, adding, however, that no meeting had been called. Thereafter, subsequently, the matter came up. He had also sent letters so. RP came to know on 21st November 20 CD had made huge withdrawal. See, 27th October, sorry, 27th September, CRP commenced, but the suspended management has made huge withdrawal, including cash withdrawal from the CD's bank account. See the cash withdrawal. Name of the recipient, Deepak Kumar Daga, suspended management, Puja Trading, all these are fellow member of the CD, the suspended management. They withdrew the amount 25th October 2019. Thereafter, again 2 crores, 85 lakhs, 24 lakhs. These withdrawals took place after commencement of CRP or after declaration of
Sir,
moratorium.
may I interrupt?
Yeah.
It's case is Deepak Kumar Daga? Which
Yes.
Deepak Kumar Daga pronounced by NCLT on which date?
This is pertaining to 2020 case.
But in 2020.
Yeah, but this is important. That's why I have taken this case today.
Yes, sir. That is why I'm just asking you. Deepak Kumar Daga 2020 case. Which bench, sir?
Just a moment. It is enclaved just New Delhi.
New Delhi. Okay.
Yeah. Appeal was filed in 2019 and decided in February 2020.
Highly obliged.
Actually, at that time, there was only one bench of enclave, I believe.
Pardon?
At that time, there was only one bench of enclave at New Delhi.
Yes.
Chennai bench had not been established.
No, Chennai was also there that time.
In 2019, I don't
In
think.
2000, I think
It's a case of 2019.
only one bench. In 2019, Chennai was established, I think 2020 or
That's right.
2009. Yeah. So, in this case, withdrawal took place during the CRP period. by the suspended manager. RP pointed out the deposits of accounts so amount transferred in. Then again some amounts were also transferred in the, no, this is different thing. Just a moment. IRP pointed out deposits of an account between so. Name of the donor, amount transferred, Giriraj Solvent, expenditure 4 crores, 54 lakhs. The IRP attached the bank statement in the support. The IRP pointed out that on 17/11/19, the balance left in the bank account mere 6,315 only. London IRP, the IRP referred to the steps IRP took in these given circumstances and stated that bank account of the CD was being used without prior approval of the IRP in the breach of the direction passed by this honorable tribunal. IRP prayed that interim order should be modified. Order so and so and so and so. IRP referred to the IRP filed by the diary number so and so and so and so. We modify the order dated so and so. What was the order? Just a moment. I'll reply. It was for reply, and thereafter Director CD are unable to show the prior approval of with regard to the interim loan withdrawal. Section 74. He also invoked the Section 74. That is the breach of the moratorium. We modify the order dated so and so. The person who is authorized to sign bank checks may issue checks, but only after approval of the IRP, which is deleted, and we substituted the same by the direction. The person who is authorized to sign the bank checks may prepare and sign checks, but only after approval of the IRP, and the checks can be operated or issued only through the hands of the RP. On the next date's appeal, so appeal filed by the IRP will taken up together for hearing. The reply may be filed. So the matter was then posted on on the date of the learned counsel. For the appellant referred reply diary number. Chairperson posted the matter. It was again listed. So these are all procedural aspects before the enclave, that rejoinder, reply, written submission, then interim order, modification. Then the chairman posted the matter so and so hearing. It is the progress of the hearing. And thereafter, withdrawal made by the suspended board of directors. Interim order passed by the tribunal. Name of the recipient. Withdrawal made by the suspended board. Same. Counsel for the IRP stated that the total amount withdrawn and or transferred was 6.72 crores. He was pointed out that after the order of this tribunal, the directors had returned back amount of rupees 40 lakhs and again 50 lakhs only. Our order dated so and so read as follows. 3/2/2020. Learned counsel for the Prachi Johri in IA numbers. This application filed by modification of order. IRP stated that the IRP has given particular in continuation of IA. These are the all procedural aspects. The directors of Manoj Kumar Daga and Ms. Lipaga are present today. They might file undertaking with affidavit as stated that the money would be returned within 4 weeks. The same may be filed by tomorrow. List the IA and appeal in order dated. The matter then came up before us on 5th February. And we passed the following order. What is the order on 5th February? This is very important. The respondent in IA number so have in response to the order dated 3rd February filed an affidavit. The affidavit filed by Sri Deepak Daga in diary so tendered so Prachi. So they have filed the undertaking and affidavit. Undertaking by they have signed the affidavit undertaking. Both these respondents are accepted and taken to record. These respondents shall comply with the undertaking given. The learned counsel for the IRP accept that rupees 5 5 crores needs to be returned. So this was affidavit and undertaking. The amount which were withdrawn by the suspended management, the affidavit and undertaking was given by the suspended management that they will return the withdrawn amount within and will deposit in the CD's account. So IRP, the learned counsel for the IRP accept that 5.5 crores need to be returned. The learned counsel for the appellant states that the appellant is taking steps to settle the dispute with the original operational creditor as well as the sole financial creditor, State Bank, and will make efforts to settle with the OC. See, it was the OC application, Section 9 application, whereby the CRP commenced. So he said, the suspended management said, instead of depositing, first of all, he has given the undertaking affidavit that we will deposit everything. Thereafter, he taken different stand. No, I will settle this matter with the OC and SBI, that is the FC, and will make effort to settle the OC and other OCs also. The council makes request to continue the IRP. Sorry, the council makes the request to continue the interim order not to constitute COC for short period to give time to the appellant to settle with all the debtors. For the reason stated above, one opportunity is given. List the appeal so 26th February. So it was on 5th February, now 26th February. Before which the date of the appeal must be ensured settlement as stated by the learned counsel. In default, we will proceed to vacate the direction with regard to the constitution of COC. The undertaking given were thus accepted. Counsel for the RP did not remind us on this date contents of the proceeding noted in the earlier order of dated 18th November 19 that our orders regarding COC was qualified orders ineffective as COC had already been constituted before before interim order dated 23rd October 19 was passed. So COC was already constituted on 18th November and order was passed on 23rd October. The undertaking given by Mr. Daga on 5th February is as under. What is the undertaking? I, Manoj Daga, so grant, if the tribunal grants me time of 4 weeks from 5th February 2020, time up to 4th March 2020, I along with my co-director, Mr. Daga, Deepak Daga, shall ensure deposit a sum of rupees 5.5 crores into the account number so in the name of Sri Vishnu Power and Energy Private Limited, maintained with the Vijaya Bank within 4 weeks. Mr. Deepak Daga has already deposited some rupees 1.22 crores as follows. So he has deposited out of 5.5 crores, he has already deposited 1.22 crores. Now come to similar undertaking along with the affidavit is given by Deepak Daga, white orders also which are as under. Undertaking by Deepak Daga. So I shall deposit. If a tribunal give me time 4 weeks, I shall deposit 5.5 crores. No, I think this is different. It is over and above. 5.5 crores and 1.22 crores. So 5.5 crores plus 1.22 crores. Because here Deepak Daga is he has given this undertaking for 5.5 crores into the account of Sonsa in the Vishnu Power with Vijaya Bank within 4 weeks. I have already deposited a sum. Oh, sorry, same. So I out of 5.5 crores, 1.22 crores deposited. Now come to here. Now we are in 26th February 2020. The proceeding dated 26th February 20 shows as further. Learned counsel for the appellant states that the appellant has settled with the original operation creditor and is also making efforts to settle with only FC. What he said, he has already settled with the OC and is making efforts to settle with the SBI and making efforts to settle with other OC also. who have responded to the IRP. Appellants may continue with the efforts
Excuse me, sir.
made.
Excuse me. This is
Sorry.
Rao here. Yeah, is there any lapse on the part of the interim resolution professional in this regard? Has he not advised the banker to stop the transactions immediately after commencement of this thing?
No. See, IRP is nobody to stop the settlement, etc. It is the only all
No,
the
not the settlement, sir.
yeah.
Not the I am not talking about the settlement.
Yes, please.
The corporate, the suspended directors have withdrawn the amounts from the bank
Yes.
after commencement of say ARP.
Yes.
So there are any lapses on the part of bank or the IRP for allowing
No,
such?
there is no lapse. Because IRP has taken immediate steps against the CD, against the suspended management for violation of this moratorium, and he also invoked Section 74 for violation of moratorium. Now I'll come to the main point. See, only 5 pages.
No, actually, the question is different. Actually, the question is once the IRP takes over the enterprise, which is put under CIRP, he is immediately required to notify to the banks that the CIRP order has been passed, and therefore the bank should not
So I
allow the
think,
operation of the accounts.
see, I think what happened here, these facts are not mentioned. I'm just telling. I have gone through last 2-3 paras. I'll come to that main paras also.
In fact, this appeal,
It is
in
duty of the
fact, this appeal
IRP.
was
I agree. Mr. Dr. Rajneesh, I fully agree with you. Whenever we take the charges and IRP, we immediately first hit the bank. Please stop all debit transaction. And that is the duty and the most important part of the IRP. Please stop the debit transaction immediately. So here, after 1 month, he has withdrawn. 2 months, 1 month or 1.5 months, they have withdrawn. So I'm just wondering how this bank allowed to withdraw and why IRP did not took the note of this. This might be due to, I think he must have suppressed the bank account details from the IRP. I think because it is not mentioned what is the lapse on the part of the IRP. So I'm just coming the main issues of this case. Just coming. We have already discussed the issues. Now, how this case is progressing. CD suspended management is saying at one hand he is saying I am giving the undertaking affidavit that I will deposit 5.5 crores within a period of 4 weeks. Out of 5.5 crores, I have already deposited 1.22 crores. On the other hand, he is saying that I am also settling with the SBI, FC, and I have already settled with the OC who has filed the Section 9 application. And I am also in process to settle with other creditors. So these two types of these events are going on concurrently. Now come to, this is very interesting. That's why I have taken this case. It came to my knowledge today only. It is stated that the appellant and directors are taking steps to ensure that they comply with the undertaking given on 4th February 20.
But this appeal was in any case dismissed because they had not complied with the undertaking. And then the directions are issued maybe to RP.
Yeah, that's why I'm coming to the this effective part also. London Council for the IRP states that the order dated so and so had directed IRP not to constitute COC. I think due to stay order of this tribunal, the signatories has not been changed. What I am just guessing. Because of the stay order of the enclave, the COC was not constituted. Sorry, due to this IRP did not change the signatory or did not inform the bank. You raised one question, Mr. Rao, that why IRP?
Yeah.
So your answer is here because of the stay order on the CIRP that IRP will only run the CD as a going concern. No COC meeting will take place even if COC has been constituted. So I think IRP has not taken any further step to stop the bank operation, to make the change of signatories. He has not done all these things because of the stay order. only the direction was given that IRP will run the CD as a going concern. So without operation of
I mean, it must be MSME.
No, but I think that you see the
Is it an
COC was
MSME?
constituted before the restraint order passed by the adjudicating
correct,
authority.
correct. COC
So,
was constituted, but there was
which,
no COC meeting. No
yeah,
COC meeting.
which happens generally after a month,
Correct.
because
So
after
COC,
1 month when we have received all the claims,
yes.
4 to 5 weeks time was more than enough for the insolvency professional RP to inform the bank and stop the payments of checks issued by the directors. So
Mhm.
that information is missing from this.
I think that facts have been missing here. And if this is not done, then it is the lapse on the part of the IRP because he should have
Exactly. Yes.
informed.
Yes.
So I'm just coming to next this events that what happened
Yeah,
there.
there may be other regions like the order itself has been uploaded by late, and in between the date of the commencement of CIRP and the actual order being placed, the monies has been transferred. In one of my case, this has happened.
Very true, very
So,
true.
so
Yes,
there may be so many regions. If there is nothing mentioned in the order against IRP, it means otherwise no one is going to leave IRP. So
yes, yes.
if there is any lapse of IRP, it must have been noted in the order. If there is nothing mentioned, it means there is no lapse.
Yes. So I think you are right that there might be a situation that IRP has received the CRP commencement order much later. So now come to next, if not yet considered, it is stated that before order. Now record does not shows that we have directed the IRP not to holding the meeting. The direction was not to constitute the COC if not yet constituted. If it was already constituted, natural course under IBC will follow. In view of the matter, IRP may hold the COC meeting. List the appeal on 12th March 2020. Now on 12th March, just before the corona period, 1 week before the corona period. Today the Learned Council, Senior Council for the appellant states that the appellant had moved the Honorable Supreme Court in Mr. So-and-so versus Manoj Kumar Daga versus IGS High Heavy Engineering Civil Appeal number so-and-so and by order dated 6th March 20, Honorable Supreme Court directed as under. We are not inclined to interfere with the order passed by the tribunal as the case is listed before the enclave on 12th March 2020. The NCLAT may decide the matter if possible on 12th March 2020 or as expeditiously as possible. The COC may hold the meeting, but the order not to be given effect not to be given to till 12th March 2020. The NCLAT may consider whether it is appropriate or to extend the aforesaid order or not of not giving the effect to COC decision. The appeal is disposed of accordingly. So Supreme Court has given complete liberty to enclave and given the time frame also. Now the Learned Senior Counsel for the appellant states that the appellant has filed IA number so and so and sought further time to return the money. See, now after giving the undertaking was given for 1 month, 4 weeks, and the deadline was 5th March or 4th March, something. Now we are on 12th March. The undertaking affidavit was given on 3rd of February for 4 weeks. It was 5th March or 3rd March, something. But now we are on 12th March. What is happening here on 12th March? The Learned Senior Counsel for the appellant have been making various efforts to collect the money. So he is asking further time. So that he is making various efforts to collect the money so as to return back the same. It is stated that the appellant has entered into an agreement with the original OC to settle his claim. However, it is stated that agreement is subject to closure of CIRP. See, in that agreement, he has already settled, but agreement was subject to closure of CRP. The conditional agreement happened. Conditional agreement was executed. The Learned Counsel for the SBI, the sole financial creditor which constitutes the COC, submits that there is no settlement or possibility of settlement. It is stated that State Bank had to recover 45 crores in September 2019. The Learned Counsel for IRP submits that these directors had withdrawn most of the amount of the CD after the CRP had been initiated, which is clearly not permissible when the moratorium had been applied. The Learned Counsel for the IRP states that COC meeting has been held on 6th March, but if the IRP is unable to give effect, the CRP itself would get stranded or stayed, and given the fact that the amount withdrawn in an illegal manner after the moratorium had been imposed, no further time need to be given. Learned Counsel states that the IRP is under the responsibility under the provisions of IBC to keep the CD as a going concern, and if almost the whole money which was in the bank account has been withdrawn, the IRP has been rendered helpless in this situation. See, the money has been withdrawn. The money is the lifeblood of the CD. If blood has been extracted from the body, how body will function? So he has taken the same plea here. So entire money has been withdrawn by the suspended management. The Learned Counsel for the appellant states that although the money was withdrawn, it was for the purpose of keeping the business going concern. The Learned Counsel for the IRP in reply states that the IRP has verified each and every entry of the amounts which were withdrawn, and according to the IRP, except for an amount of rupees 8.95 lakhs, which could be considered as CRP cost, the rest of the amount withdrawn and spent cannot be treated as CRP cost or expenses, and which would be a serious violation of provisions of IBC. As to how past debts are to be treated and CRP conducted, the Learned Counsel for the IRP has handed over to us a statement at bar which is taken on record and marked as X for identification. It is stated that this chart was given to the appellant on the last date itself. It is stated that even IRP could have utilized only 8.95 lakhs as shown in the table 3 as CRP cost. Rest of the amount withdrawn or transferred is illegal and against the provisions of IBC. The whole process has been illegally interfered with. Now last 2 pages more. The Learned Counsel for the appellant states that the appellant has good case on merits in this appeal, taking conceptuous of the whole development in this CRP proceeding and this appeal. We are of the view that directors acted wholly illegally once moratorium had been applied in going ahead and withdrawing monies from the accounts at the back of the IRP by even issuing checks self. Such acts cannot be justified in any manner. The appellant and Deepak Daga kept telling this tribunal that they would return the money, and in spite of undertaking given and time fixed, the money has not been returned and the CRP process is seriously hampered. Consuming whole month stated in the undertaking and without returning any money. We find no substance in the hollow statements in IS also. Application seeking time comply with the undertaking. The IO wrongly states that undertaking given were without prejudice. They were voluntarily given. There are no bona fide in seeking the time. Looking to the statements made to this tribunal by the appellant and Deepak Daga through Learned Counsel for the appellant, and the affidavit and undertaking given which have not been honored, we are of the view that prima facie case is made out for the proceeding against both the directors in contempt. We are of the opinion that appellant and Deepak Daga, since beginning, were aware of the nature of the acts they were committing in the illegal withdrawal. They disobeyed the order of AA, and this tribunal willfully, and there is willful non-compliance of the undertaking given in IA so and so to seek time to comply with undertaking is not honest and appears to have been filed to create ground of defense to further abuse process to kill the time. The IA is rejected. The acts of two directors have obstructed the proceeding of CRP, the proceedings before AA and this tribunal. The acts prima facie disclose serious contempt, violating mandate of IBC, mandate of law of IBC applied by the orders of AA and this tribunal and breach of undertaking given on oath actionable as NCLT established under the Companies Act 2013. As AA and tribunal is empowered under section 425 of the Companies Act 2023, read with enabling provisions to take the action. So this is for your knowledge that whether in one of the case, principal bench has objected, earlier bench of the principal bench Delhi objected that AA has no power of contempt to proceed, but Companies Act has given this power to AA and enclave under section 425 to initiate contempt proceeding. This has been held by the enclave also. So that's why I am reading this judgment very carefully, and also I am apprising you, please remember this judgment for future proceeding. In one of my assignment, this was happened. In my case, what happened? The suspended management has sold the entire property, entire showroom, on the basis that he was claiming that property belongs to me, whereas as per the balance sheet was showing that balance sheet was showing that the building belongs to CD, but land belongs to suspended management. So what he did, he sold the entire property during the CRP. I immediately moved an application before the AA to grant the stay, and this buyer cannot further sell off and cancel the sale deed. So this matter is still pending. Some other person is looking after this matter now. So this usually happened. Despite of the knowledge the CRP has commenced, I have seen many cases, the directors withdrawn money or paid the suppliers to non supplier like that. Now coming to this point, 425 I have already discussed. The power has been given to the AA to initiate contempt proceeding. At the same time, considering record which shows that appellant violated orders of AA and this tribunal, and looking to the apparent default on record, where undertaking were given and not honored. Even undertaking was not honored. We find that the appeal deserves to be dismissed in default. We dismiss the appeal in default while permitting the IRP to move the AA or any other authority, including police authority, to pursue the matter with regard to the money illegally withdrawn from the account of the CD so as to trace the money and get it back in the company's account. Prima facie, it appears to us that the illegal withdrawal can inter alia be treated as criminal misappropriation and criminal breach of trust. 406 of the IPC. क्रिमिनल ब्रीच ऑफ ट्रस्ट 406 आईपीसी का अब चेंज हो गया. नाउ इट हैज बीन चेंज. भारतीय न्याय संहिता, नाउ न्यू सेक्शन हैज कम. The provisions are same, but section has been changed. The appellant Manoj Kumar Daga is present. The other respondent Deepak Daga is stated to be not present as not well. Copy of this judgment and record of this appeal will be treated as contempt case. This appeal will be treated as a contempt case to be registered as State versus Manoj Kumar Daga and Deepak Daga. So now the title of the case has been changed. Now State will proceed against the Manoj Kumar Daga. as the director who will face the contempt case. The registry will give the
Is
contempt.
it against Manoj Kumar then?
Now this appeal has been converted into contempt of court case. The registry will give it a contempt case number and the same be listed on 7th April for the appellant state that on that day Manoj Daga Kiva both attend this tribunal. The CRP proceeding will continue in terms of provisions of the IBC. The IRP would be at liberty to examine the accounts and evidence and may place before AA all particulars and facts including evidence showing violation of section 14, 17 and 19 of the IBC after impugned order dated 27th September 19 was passed and during the pendency of the appeal. For AA to consider and take action under section 70 and 74 of the IBC or other provisions as the case may be. The appeal and the IA are disposed of accordingly.
So what happened subsequent to this case, like the NCLAT ordered that this should be treated as state versus so and so case, because as far as I understand under the Contempt of Courts Act 1971, this is not a cognizable offense, and state can become a complainant only in a cognizable offense.
See, here the case has been proved that contempt has taken place.
No, contempt has taken place. That means this punishment has to run under as per the Contempt of Courts Act.
Yes. So that's why the cause title of the case has been changed from Deepak Daga to State. State versus Deepak Daga and Manoj Daga. The title
No,
of
but
the case has
name
been
of
changed.
state, as I understand, I'm not able to understand this aspect. If you can help me on that, because the state can become complainant only when there is an offense under IPC. Otherwise, how the state will come as a complainant? It appears to be some error in the judgment. Because contempt, only the court whose order has been infringed is competent to pass a punishment. Like NCLT or NCLAT, they have the power of contempt. That's specifically provided under Companies Act. Otherwise, the power with respect to punishment under the Contempt of Courts Act lies with the High Court of a particular state. But here, because there is infringement of order of NCLAT, so NCLAT could itself have awarded the punishment for contempt if the case of contempt is already made out.
No,
And the
but
punishment is maximum.
proper chance has to be given
Absolutely.
for
So
them to be
that
heard. That's why it is a prima facie established that there is a contempt. And once
so
there is a prima facie, then it can be registered as state versus that person,
no,
and that person will be given opportunity to establish that he is not contempt. He is not in contempt.
no, state versus case can be registered only in case of an FIR. Otherwise, how the state case can be made out? State case cannot be made out without there being an FIR.
Shall I
How
say
the
something?
state? Yeah, please, yes.
Yeah.
आपसे सुनना चाहते हैं.
Thank you. First of all, the contempt has been established, number one. Number two, section 425 of this Companies Act clear cut gives power to AA and NCLAT also to initiate contempt proceeding. Okay. So here, NCLAT has exercised its power under section 425 of this Companies Act and initiated contempt proceeding and changed the cause title. State versus so and so. One hand. See, I think you have missed it. There are two double बोलते हैं ना एक दुधारू तलवार जो होता है यहाँ दो तरह there are double proceedings will be going on and against the suspended management. One is the contempt, another is section 74 of the IBC, penalty, imprisonment, etc., etc. Shall I read 74? Just a moment. So
No, but then who will represent the state?
see, 74 will be invoked by the IRP. He has already invoked. So 74 case will be section 74 proceeding will be handled by IRP. Content will be handled by NCLAT, suo moto.
No, that's right. Contempt will be handed. That
And
means
you know, see,
that means in this case now the respondent or the accused would be given the opportunity to defend his case, opportunity to state his case in view of the principles of audi alteram partem.
Already
So
given, sir. He was given opportunity to give the undertaking. He was
no,
given to opportunity to
once
comply with the undertaking. He didn't
no,
comply
once
with
the
the
court
undertaking.
says now this case will go on as state versus so and so. So before which authority this court case will go? Because if there is a case, it has to be before a court.
Just a moment. Let me read section 425.
Yeah, no, 425 is very clear. There's no doubt about it. 425 says that the NCLT and NCLAT will have the power of contempt.
Yes, the tribunal and the appellate tribunal shall have the same jurisdiction, power, and authority in respect of the contempt themselves as the High Court. You are saying the High Court should have taken no. The High
Absolutely.
Court powers will
No,
be.
no, no. Here, that's what I'm saying. Okay, under 425, specific power has been conferred on NCLT, NCLT.
Yes,
Had it not been, if 425 would not have been there, then the power would lie with the High Court. Because as per
correct.
the Contempt of Court Act, only
Very
High Court, unless the special statute gives the power. So here the power is there with NCLAT. That is
yes.
fine. But the order that you just read to us, that NCLAT has now said that this case will become a state versus so and so case. But who will adjudicate this case? If we say this case is already stands adjudicated, but there is no punishment given.
No. Enclave will execute. Enclave will adjudicate.
Okay, so if NCLAT will adjudicate, then who will represent the state? State means what?
The state means the Standing Council of the Government of India.
No, standing council. The council cannot be the
See,
state means state government of state means the city of Delhi, or state means what? State means government of Punjab, or state means
this company, I think,
because when a case
sorry,
is filed with the police, it is filed
this,
in the on behalf of the state
just a
government.
moment. This enclave was, NCLT was of
State
which?
is
Just a moment. एक मिनट. ये NCLT कौन सा था? एक सेकंड.
Katak.
कटक था ना, तो कटक का उड़ीसा. Then State Council of Odisha, the Standing Council of the Odisha government will represent state, and the respondent or the accused will be the suspended management.
Can you please take us back to that particular portion
Cutter.
of this order, last line?
This is the Cutter bench. Now come to the operative part. There are two proceedings. You have missed this thing. There are two proceedings. Number one, the violation, the for violation of moratorium and violation of order of this enclave, contempt of court proceeding will be started. Now come to the here. Here the CRP will continue in terms of the provisions of IBC. The IRP would be at liberty to examine the accounts and evidence and may place before AA all particulars and facts including evidence showing violation of section 14, 17 and 19 of the IBC. After improved
Sir,
order.
will it not come under section 236, trial by
Just a moment.
criminal
Just
special
pass
court?
by the during the pendency of the appeal for adjudicating authority to consider and take action under section 70 and 74 of IBC or other provisions as the case may be. So there are two cases. Now IRP will take action under section 70 and 74. What is 74? Just a moment. Criminal proceedings and heavy fines.
74 is punishment for contravention of
Willful and
moratorium.
material omission from statement relating to
Yes.
affairs of carding.
So that
Sorry,
action
sorry.
will be taken
Punish-
by the AA.
No, sir. 74 is punishment for contravention of moratorium or the resolution plan.
Yes. Just a moment. I'll just reading the exact provisions. What is provision? Punishment for contravention of moratorium or resolution plan, where the CD or as the case may violates the provisions of section 14, or any officer who is knowingly or willfully committed or authorized to or permitted such contravention shall be punishable with imprisonment for a term which shall not be less than 3 years, but which may extend to 5 years, or with fine which shall not be less than 1 lakh rupees, but may extend to 3 lakhs rupees or both. So,
But this will be adjudicated only before the special court, as per section
sir,
236.
sir, let me complete, sir. Sir, here the punishment.
This punishment will not come under special court.
Sir, 3 years. सुनिए, इसमें क्या है? 3 years to 5 years so imprisonment है, and fine है 1 lakh to 1 lakhs to something. Now, what
3
will
lakhs.
happen? Once since IRP has already established and CLAT has also established that there is a violation of section 14. Now, what will happen? AA will refer this matter to the special court.
Correct.
Okay. A special court will try this matter and will punish the accused. Very simple. I have seen one cases where a special court has issued the notice. District judge of the Gurgaon court issued the notice to the IRP for cross examination. After cross examination, the case was established and he was punished. The directors was punished. So what happened in this case? अब क्या है, आईआरपी ने तो अपना काम करना शुरू कर रहे हैं, लेकिन अब मान लेते सपोज समटाइम्स व्हाट हैपन, वी थिंक दैट आई एम सिटिंग इन दिल्ली, we can take up the matter of Cuttack, we can take up matter of the Ahmedabad, we can do this CRP. But in this case, what will happen? How IRP will be grilled? He will have to visit to the court for cross examination, for witness and everything before the special court. So these difficulties comes after the it comes in this situation. So there are two proceedings. One is the contempt of court. Another is section 74 proceedings. And 70s, what is 70s? Punishment for misconduct in the course of CIRP. Punishment for misconduct in the course of CIRP. So same, the punishment is 3 years. Shall be punishable.
Not less than 3 years, extend to 5 years.
Yeah, 3 to 5 years. The punishment is, and the fine is also same.
1 lakh to 1 crore.
Yes. So punishment, there are
Both.
two sections which will be invoked by the IRP. Punishment for misconduct. So this judgment is lesson for all IPs. Shall we take break of 5-10 minutes?
Sure, sir.
Okay.
Okay.
Thank you.
Yes.
Otherwise, we haven't taken break since morning.
What?
First session was not there. Is there any news about the first session? This didn't happen.
Nothing. No
Pre-lunch
mail has
session was
come.
not there.
No further communication on that.
There is no
I think
communication.
they will do it later.
ICSI representative, can you tell me the name?
Yes, I am Saurabh Haldar.
Saurabh.
Ji, sir.
Acha. Saurabh ji, what happened in the morning? Somebody is asking why morning session did not take, nobody. Yeah.
Actually, there is some medical emergency of Mr. Vinita Nagar.
Okay.
So the speaker wasn't able to take the session.
No,
The
that's
session is
fine.
postponed
There
now.
should be communication actually, because we just kept waiting.
Sir, we actually informed at the very beginning of the session.
No. Saurabh ji, what should be happened? I think there should be a separate email to all these participants who has registered. There are, I think.
Mail has come, sir.
There
Mail has come.
Acha, mail has come, na? Okay.
I have not received that.
Yes,
such
sir.
mail.
Mail has been received, sir. When this session will be done?
Actually,
There is
the
no.
further will be communicated shortly, sir. Like we actually making the new date will be communicated for the session.
Whether it is possible to do this session tomorrow morning?
Sir, my team will look into it and get back to you.
Please.
Okay, sir.
Okay. Thank you. I'll again join at 10 past 3 or 7 past 3. 10 minutes. I'm just taking 10 minutes. Thank you.
Okay.
Good afternoon, everybody, once again, and welcome to this second session.
Good afternoon, sir.
Yeah. So we were discussing latest case and important case also. We have discussed two important cases. Now we will discuss another important case, that is recall versus review. You must have heard this word, recall versus review. My question is whether NCLT can recall the order. I put one question before you, whether NCLT recall its order.
No, sir. No. They have no authority to recall or review.
Okay. And what about review?
Review also is not there.
Okay. So what is the
No, NCLT can recall its order in certain circumstances, because there has been recently a judgment, 5 judgment of NCLAT, which was found by Honorable Supreme Court also, that in case there is any order procured by anybody by playing fraud, then in such circumstances the NCLT is competent to recall its order. But there are very limited circumstances under which NCLT can recall its order.
what about review?
Review, NCLT, no court can review its own order unless there is a specific power granted by the special statute.
Very true. So what is the difference between recall and review?
Review means the reconsidering its decision, maybe on the basis of some new evidence,
Correct.
on the basis of some new contentions. And recall is where the order is patently illegal, is without jurisdiction, or maybe is procured by playing fraud with the court. Then that order has to be recalled.
Not only that, in many circumstances, recall can be done. Suppose there's
Lack
some
of jurisdiction, it can be done.
no, some error or something. No. See,
No, error generally for error, there is a provision, always a provision institute. If there is any error apparent on record, then NCLT can correct it. Even here, I think 2 years time is given in NCLT rules that if there is any error that can be rectified, but that doesn't amount to review or recall.
see, the basic difference between these two is the matter of recall, the merits of the case is not considered. While in the case of review, the court has to enter into merits of the case. So merits, अगर case का कोई merits है, कोई fundamental things है, it cannot be changed. That will be called as a review. But if merits of the case doesn't get any effect, it is not affecting, then recall can be done. So recall में merits of the कोई केस में किसी चीज को डिसीजन दे दिया कि ये होगा, अब उसमें क्या होना जो कोर्ट ने ऑब्जर्व किया, सम ऑब्जर्वेशन इज सपोज रॉन्ग, सम ऑब्जर्वेशन इज सब कहीं मिस्टेक है, देन इट कैन बी रिकॉल. बट उसने ऑर्डर पास कर दिया, सीआरपी इज एडमिटेड, सेक्शन 7 इज एडमिटेड, नाउ इट कैन नॉट रिव्यू. NCLT cannot review its order. No, it is the admission was wrong. I am withdrawing this order or I am reviewing my order. It is not possible. It can recall certain observation made in the admission application or certain error in the application, in the order. Sorry. So you have rightly pointed out, but the fundamental is the merits of the case. We have to check whether if it is affecting the merits of the case. It is not jurisdiction of the AA or NCLAT. Recent judgment, just a moment. NCLT rules. I am just touching the head notes. AA, adjudicating authority, can recall its judgment but has no power to review unless expressly required. NCLAT. In the case of so technical member, dismiss the appeal filed by the Ear Castle, who was agreed by the order of AA. The bench distinguished between the review petition and recall petition and stated that adjudicating authority have have the inherent power to recall their orders but have no power to review the same. The appeal has been filed under Section 61 of the IBC against the order of AA by Air Castle. The appellant entered into a lease agreement of 2 aircrafts fitted along with their engines and APU respectively with the respondent. Due to the default in the payment in accordance with the lease agreement of both the parties, both the aircrafts, the following aircrafts were deregistered by the DGCA and were repossessed by the appellant. So here the petition was admitted, but the application was filed for actually, this is the only head note. I have not collected the complete judgment, but fundamental thing is that the order can be reviewed, so recalled, but it cannot be reviewed. This is the basic concept. And the recall and review review denotes to only merits of the case. Recall denotes to only observation or certain error in the order. That's it. Like in Constitution of India, what happened in Keswananda Bharati? The basic structure of the Constitution of India cannot be changed. It is settled law. Nobody can change. Even Parliament, even Chief Justice of India cannot change the basic structure of the Constitution. Here, similarly here, the merits of the case cannot be changed by the AA or unclaimed. Very simple. Now, come to next. Implementation of resolution plan. Timely implementation of resolution plan is crucial to achieve the IBC objective of protecting the assets dissipation. Supreme Court. Supreme Court, see, I'm just reading the head notes instead of going into merits. Supreme Court bench comprising so-and-so held that unnecessary delay caused in implementation of resolution plan would also leads to assets of the CD diminishing in value. Therefore, there is no doubt that the timely implementation of resolution plan is also one of the underlying objectives of the IBC. This was held in, I think, Jet Airways case. Just a moment. Name of the CD is not mentioned here. But this was held in the Jet Airways case. Can unregistered MOU be treated as an agreement for sale and Section 18 of the RERA be invoked? Will provisions of RERA Act will prevail over the Arbitration and Conciliation Act? Can delay in the granting of permission, sanction from various competent authorities, litigation in the court be construed as force majeure? These were the issues in this case. Whether MOU be treated as an agreement or not, which is very important. Can anybody say whether an MOU, because most of the time, even we enter into an MOU with the PRA, prospective resolution applicant, or SRA, sometimes, or sometimes in our practical life also we enter into an MOU for sale of some assets or property. So whether this MOU be treated as an agreement, can it be enforceable by the law? Dr. Rajneesh ji. You are not audible. Please. आपका कहीं फ्लक्चुएट कर रहा है. हाँ मिस्टर राव, आप बताएंगे.
No, sir, I don't. I have no idea, but MOU is a private kind of thing. So I can't. It cannot be subjected to any legal.
See, I will come to the
Actually, memorandum of understanding. Am I audible now?
yes. Now you are audible. Please.
Yeah, yeah.
Memorandum of understanding is also an agreement. Actually, it outlines the terms and conditions of arrangement between the parties, and it depends upon the terms and conditions of the MOU to see whether it is enforceable or not. Where there is a proper consideration provided and exchange between the parties at the stage of execution of memorandum of understanding, then of course it will be enforceable. And in case there is no consideration exchanged, then of course an agreement without consideration, we all know.
Correct. So see, the enforceability is the criteria. So we have to test the ingredient or contents of the MOU, whether it fulfills the section 10 of the Contract Act or not. There is consideration, there is a parties, there is a all these things, the criteria should meet. If it all meets, then
That
nomenclature,
means
title of the
irrespective of it is registered or unregistered.
yeah. See, registered, unregistered will come later on. First of all, we'll see the enforceability. Enforceability will only triggers through Section 10A of the Contract Act. Nomenclature doesn't make any difference. Whether you write MOU, whether you write agreement, if terms and conditions satisfies the Section 10 of the Contract Act, then it is binding to the parties. It is enforceable. Now come to the registration part. If instrument is compulsorily registrable, then it has to be registered. Without registration, it will not be admissible in the court of law. If stamp duty is also not paid, then it will also not be admissible before the court of law. Now we'll come to the the complainants have booked the 2 flats so. Come to I'll just read the conclusion part. One para above, the provisions of RERA have been overriding effect in the case of repugnancy with the Arbitration and Conciliation Act. See, RERA is having overriding effect over the arbitration. Promoter has contained from the discussion herein above, mere non-execution of the agreement for sale, complainants are not precluded from invoking Section 18 of the RERA. So, here in this case, only MOU was executed. So, formal agreement was not executed. So, he cannot absolve from the penal provisions of RERA. Merely that agreement was not there. Agreement for sale. The provisions of Section 18 of the RERA can be equally invoked in terms of oral or formal agreement executed by the promoters, developer, such as booking application form, formal letter, letter of allotment letter, letter of intent, memorandum of understanding, etc., capable of being construed as an agreement. Letter of intent is an agreement. Suppose CD issue LOI and the recipient accept the LOI, it becomes agreement. You cannot say that I have just issued LOI. The offer and acceptance becomes agreement. This is very fundamental things. We should know all these things. The said MOU has also all the essential ingredients of an agreement capable of being construed as an agreement. Admittedly, the said project is ongoing project, and as per the view taken by this tribunal, in catena of cases, provisions of RERA are applicable to this project. Accordingly, the MOU signed between the promoters and complainants prior to RERA are enforceable under Section 18 of the RERA. Section 18, I'm just reading all these things because what happened, most of the CRP happening pertaining to real estate company. So being an IRP or RP, we should know all these provisions about the enforceability of the contract. Now come to next. can anybody say that suppose flat buyers or flat allottees is aggrieved with the promoters, with the developers, real estate company, and the cost of the flat says 2 crores. He has paid the 2 crores, but builder has defaulted in delivering the project and breached the terms of the builder buyer agreement. Am I clear? Now, my question to you, how many remedies are available to the flat allottees? Which forum he should approach to which forum in case of default by the builder? Yes, sir. Mr. Rao, आपका विंडो ओपन हो गया, खिड़की खुल गई है आपकी, प्लीज.
Yeah, it can be through IBC, Copra also, and the IBC also they can.
अच्छा, IBC one provision. Second,
Copra is also there.
huh?
Copra. Consumer Protection Act is also there.
Okay. Can it trigger simultaneously all these forums?
Yeah. I think there is a case law on that.
So you mean to say he is having two remedies. One is under CPA, Consumer Protection Act. Another is under IBC. Any other?
Doctrine of election will be applicable. When you have more than one remedy.
हाँ बोलिए, Dr. Rajni ji, please.
Doctrine of election. Once you have more than one remedy, so for the same remedy, two forums cannot be approached. Of course, if remedy is different, then you can go to two different forums. For example, in a check bouncing case, there is a remedy of 138 and there is a remedy of recovery. These both can go simultaneously. And for a flat buyer, he can go to RERA regulatory authority, he can go to NCLT. Remedy of NCLT can be invoked parallelly because remedy of NCLT is not a recovery forum. Remedy of NCLT is for initiation of CIRP. That can be invoked simultaneously with any other remedy. Suppose he goes to consumer court or he goes to RERA regulatory authority or he may also go to the civil court.
So you mean to say he can approach all four forums concurrently?
No.
Sir, my take is
NCLT
altogether.
He can go with any other forum.
Pardon?
My take is altogether is different. Two civil remedies can't be knocked simultaneously. IBC and Consumer Protection Act remedy can't be taken simultaneously, or civil jurisdiction can't be knocked simultaneously. But one civil action and one criminal action can be done simultaneously. For instance, Section 138 or some FIR case along with IBC proceedings can be taken simultaneously.
I have a different view on this. So the consumer forum, the home buyer has a remedy not against company only, but the directors also. So even if he gets some solution under IBC or RERA, they can still approach consumer forum. There is a case law, I think, which is saying that the directors' liabilities are not extinguished under the Consumer Protection Act. Even if the person is means the home buyer is getting the flat under any other solution, means under any other law through IBC or RERA. So he can approach both the at least consumer forum can be approached along with RERA and IBC.
Just a moment. See, Dr. Rajनीsh also said correct. You are also to some extent correct. In one of the judgment of Supreme Court, it is categorically held that when the matter was sub judice, all the matter was sub judice regarding the threshold. of this threshold for the filing the Section 7 application. So in that case, Supreme Court held that flat allottees or flat buyers can approach concurrently NCDRC or Consumer Forum, NCLT, Civil Court. He can also approach for criminal proceedings. So concurrently, he can approach all forums. There is no bar. It was categorically held by the Honorable Supreme Court in 2019. I'm forgetting the name of the judgment. I will share the judgment if I'll recall. If you can share your number in chat box, I will note and I will send by WhatsApp or by email also. And I will also share my I am also yoga instructor duly certified by Government of India, Ministry of Ayush. I have been practicing yoga and also teaching yoga since 1919 1999 27 साल हो गया योगा करते और कराते हुए और I have conducted many classes. So I also share some health tips as I share today what is circadian rhythm and how our body clock works. I also share some important issues relating with the brains, epilepsies, etc., insomnias. I also share some like our heart problem. Why most of the most of you must be knowing about the heart issues, what kind of heart issues. But मैं जो आपको बताऊंगा वो बिल्कुल यूनिक होगा आपको. जैसे आज किसी ने भी नहीं बताया कि व्हाट इज सर्कैडियन रिदम. तो इसी तरह हम I touch only special topics. Even if sometimes you are aware about some health issues also, but आप उसको क्या सबकॉन्शियस माइंड में रखते हैं, उसको ध्यान नहीं देते हैं, इग्नोर कर देते हैं. अगर मेरी तरफ से आपके पास मैसेज जाएगा, देन यू विल बी अलर्टेड योर सेल्फ. अपने आप को आप अलर्ट कर लोगे कि नहीं हमें ये चीज करना चाहिए, ये चीज नहीं करना चाहिए. ठीक है. सपोज अभी विंटर सीजन है, तो विंटर सीजन है तो वी शुड टेक इन डाइट ऑल लाइक सीजनल फूड्स. क्या होता है विंटर में गर्मी का चीज खा लो, गर्मी में विंटर का चीज खा लो, तो हमारा जो वात पित्त कफ का संतुलन है ना डिसबैलेंस हो जाता है. तो वी ऑलवेज रिमेंबर कि जो भी हमें नेचर से मिल रहा है एज पर द सीजन वी शुड ईट अकॉर्डिंगली. ठीक है. तो अपना आप नंबर शेयर कर दीजिएगा. और मेरा एक और भी है मेरा मिशन कि हम एक योगा क्लास हम सेपरेटली चालू करेंगे यूट्यूब से एज पर कन्वीनियंस ऑफ द पार्टिसिपेंट. तो उसमें हम लाइव सेशन कराएंगे. तो अपना नंबर शेयर कर देंगे तो आपको हेल्थ टिप्स भी मिलेगा और ये जजमेंट भी हम ढूंढ करके आपको शेयर कर देंगे. चैट बॉक्स में आप नंबर और नाम.
That's Imperial Structures judgment, I believe.
किसमें?
Imperial Structures Limited versus Anil Patni and
नहीं नहीं नहीं, उसमें हो सकता है उसमें पुराना जजमेंट रेफर किया होगा 2019.
2020. This is 2020.
नहीं 2019 का जजमेंट है वो.
This also talks of the same thing.
उस जजमेंट में जानते ये भी डिसाइड किया गया था कि 310% और 100 होम बायर्स उसी जजमेंट में हुआ था. वो रेनबो का नहीं है वो किसी और का है. पायनियर का है शायद. पायनियर वाले में है. यस पायनियर का ही है.
Yeah, it is in Pioneer.
पायनियर ना. हाँ
Yeah,
तो
yeah.
उसमें है ये. इन दैट केस सुप्रीम कोर्ट कैटेगोरी हेल्ड दैट द फ्लैट अलॉटीज और बायर्स कैन अप्रोच ऑल फोरम्स जहां भी इसको सूट करे. तो अपना नाम और जगह का सिटी का नेम भी लिख दीजिएगा सो दैट ऑल्दो इट विल बी यूट्यूब चैनल. तो उसमें क्या होगा आपको यूट्यूब का लिंक भी मिलेगा तो आप डायरेक्ट उसको एज पर योर कन्वीनियंस आप अटेंड कर सकते हो. उसमें हम अभी हमारा प्लानिंग चल रहा है. हम एक अपना टीम बना रहे हैं सो दैट कि आपको लाइव सेशन का लिंक शेयर करेंगे. कई कोई इवनिंग का सेशन शूट करता है, कई को मॉर्निंग का सेशन शूट करता है अकॉर्डिंगली. बिकॉज हेल्थ इज वेल्थ. अगर हमारा हेल्थ ठीक होगा तो सीआरपी भी अच्छा से कर पाएंगे. और बीमार पड़े रहेंगे ना लिक्विडेशन कर पाएंगे ना सीआरपी कर पाएंगे. तो इसीलिए बोला जाता है हेल्थ इज वेल्थ. हेल्थ सही होगा तो पैसा ठीक कमाएंगे. ठीक है. तो वी शुड फर्स्ट फोकस ऑन हेल्थ एंड देयर आफ्टर. ठीक है. हाँ आपका मैं ये रख लेता हूँ स्क्रीनशॉट अपना मोबाइल में. इसमें स्क्रीनशॉट में नोट करके रहेगा. अपना नाम और जगह का नाम और मोबाइल नंबर ये आप इसको लिख देंगे तो आई विल सेव योर नंबर. आज थोड़ा सा टाइम का लिमिटेशन है, दैट्स व्हाई आई रिक्वेस्टेड दिस ऑर्गेनाइजर कि मेरा सेशन है तो 2 o'clock to 5 o'clock करो, बट सी सेड कि नो इट इज नॉट पॉसिबल, 2:30 to 5:30। देन आई सेड कि नहीं, फिर 5:30 मेरे पास टाइम का इशू रहेगा, बिकॉज बिफोर सनसेट आई क्लोज ऑल माई ईटिंग एवरीथिंग, इवन आई डू नॉट टेक वाटर आफ्टर सनसेट। तो इसलिए हमने 5 o'clock का टाइम रखा है। इनफैक्ट मैंने ये भी सोचा था कि आप लोगों को 15 मिनट का थोड़ा सा सेशन कराएंगे योगा से रिलेटेड, जो इंपॉर्टेंट चीज है। ड्यूरिंग ऑफिस आवर भी हम कुछ कर सकते हैं, ऐसा चीज जो अपने आप को फिट रख सकते हैं, बिकॉज घर में कई बार टाइम मिलता नहीं है, इतना हेक्टिक शेड्यूल होता है फैमिली का, घर का। तो उसको भी हम लोग किस तरह अपने आप हमारा ईएनटी डिपार्टमेंट को कैसे हेल्दी रख सकते हैं, अपना स्पाइन को और हमारा बैकबोन को कैसे फिट रख सकते हैं। अच्छा, एक क्वेश्चन और है, इफ यू डोंट माइंड, हेल्थ से रिलेटेड हो रहा है एक इशूज। हाँ, सेल आई आस्क? अगर आप बोलो नहीं तो केस लॉ टच करते हैं।
Yes, sir.
ठीक है ना? माई क्वेश्चन इज हाउ आवर बॉडी फंक्शंस, मतलब हमारे बॉडी फंक्शंस, जो हमारा बॉडी का जो हमारा जो बॉडी में काम हो रहा होता है, सब जो भी हम काम कर रहे होते हैं, उसको कौन कंट्रोल करता है? हु कंट्रोल दी फंक्शंस ऑफ द बॉडी? विच पार्ट ऑफ द बॉडी कौन करता है कंट्रोल सारा?
Mind.
माइंड, ब्रेन। अच्छा, और कोई?
स्पाइनल कोड।
ओके, एक बोल रहे माइंड, एक बोल रहे स्पाइनल कोड, और दूसरा?
इज इट नाभि?
नहीं नहीं सर, वो तो मेन स्विच बोर्ड है,
अच्छा,
स्विच बोर्ड
मेन
है
स्विच
वहां।
बोर्ड है। तो हमें तो ऐसे ही हिट एंड ट्रायल लगाना पड़ेगा ना, जब तक आप बताएंगे नहीं तो।
जंक्शन बॉक्स है वो। सर, ये मिस्टर राजीव मंगला जी ट्रू एंड मिस्टर प्रभु ने कहा ना, हमारा माइंड। हाँ, तो दोनों का ठीक है। अब मुझे ये बताएंगे कितना परसेंटेज हमारा कंट्रोल करता है माइंड और स्पाइन? हाँ, कैन एनीबडी से? देखिए, ये बड़ा फंडामेंटल चीज है, मैं आपको बता रहा हूँ, ये आपको लाइफ लॉन्ग याद रखना। और आज हमने जो घड़ी शेयर किया है अपने बच्चों को, जो मोबाइल में दिन भर रात भर देखते हैं, 12 बजे, 1 बजे, 11 बजे, उनको सबको दिखाइएगा ये घड़ी, कि ये घड़ी हमारा बॉडी, इसीलिए बोलते हैं ना कि रात होता है सोने के लिए, दिन होता है काम करने के लिए। उसका रीजन ये है, मेलाटोनिन सेक्रेशन स्टार्ट्स आफ्टर 9 PM। इफ यू विल अवॉइड, यू विल गो अगेंस्ट द नेचर, आपका बॉडी खराब हो जाएगा, स्वास्थ्य खराब होगा आपका। ठीक है, तो अपने बच्चों को ये आज स्क्रीन शॉट आपने लिया नहीं लिया मेला इसका?
नहीं सर, वो इससे भिजवाओ ना आप।
अच्छा, हम अभी शेयर कर देते एक बार स्क्रीन, और वो वाला
Yes,
पहले हम आपको डिस्कस कर
very.
लेते। जस्ट आई विल क्लोज वन थिंग, जो अभी अभी मैं बोल रहा था, बॉडी हमारा कंट्रोल कैसे होता है। दो लोगों ने जवाब दिया, सर ने भी जवाब दिया, डॉक्टर रजनीश जी ने भी जवाब दिया है। देखिए, जो परसेंटेज जो है ना, मैं बता दूं, मेरा अपना पर्सनल एक्सपीरियंस भी बताता हूँ क्या हुआ था मेरे साथ। हमारा जो पूरा बॉडी का फंक्शंस है, जितना भी हम आपसे बात कर रहे हैं, जो भी हम कर रहे हैं, हाथ पैर हिला रहे हैं, ये सारा हमारा 90% यहां से कंट्रोल हो रहा है। अभी हम आपसे, मेरा पूरा फोकस आपसे बात करने में है। आई एम रीडिंग, आई एम डिस्कसिंग। अगर कोई मेरे से तुरंत, अगर मेरा दरवाजा कोई धड़ाम से खटका है, मैं तुरंत चौंक जाऊंगा। देखिएगा आप घर में भी, महिलाएं खाना बना रही है और कर रही है, कोई आवाज होता है तुरंत चौंक जाती है, या आप भी कोई काम कर रहे तुरंत चौंक जाते हैं। तो उस समय कहाँ गया माइंड? हमारा माइंड 90% काम कर रहा है। अभी हम आपसे बात कर रहे हैं, हमारा अभी भी 90 या 100% मान लेते हैं, लेकिन जैसे कोई धड़ाम से आवाज करे, मैं तुरंत चौंक जाऊंगा। तो उस समय हमें सिग्नल यहां से आएगा, स्पाइन से। माइंड बिकम्स 0, इट बिकम्स 100%, स्पाइन। ठीक है, एंड दैट इज कॉल्ड बॉडी रिफ्लेक्स एक्शन। रिफ्लेक्स एक्शन, समझे? अब मैं बताता हूं इसमें क्या होता है। 90% हमारा ब्रेन काम करता है, 10% स्पाइन करता है। लेकिन कभी कभी माइंड में क्या होता है सर, देखिए बहुत इंपॉर्टेंट चीज बता रहा हूं, आपको ध्यान रखना होगा। माइंड टाइम लेता है प्रोसेसिंग में। अगर कोई धड़ाम से किया, तो माइंड में जितने देर में आएगा मैसेज, उससे पहले हमारा स्पाइन कैच कर लेता है। 0.001 सेकेंड में स्पाइन रिस्पॉन्स कर देता है। दैट इज कॉल्ड रिफ्लेक्स एक्शन। मैं बता रहा हूँ, हमारे छत पे हम वाटर टैंक हम नया लगवा रहे थे एसएस का, 4 लेयर्स, सो दैट कि पानी पीने का उसमें स्टोर हो रहा है, बारिश का पानी, रेन वाटर हार्वेस्टिंग का हमने ऊपर छत पे किया हुआ है। तो जो टंकी हमने छत पे लगाने के लिए मंगवाया था, उसमें थर्मोकोल का सीट था। थर्मोकोल नीचे जो लगाने वाला टेक्नीशियन था उसने नीचे रख दिया, उसके नीचे पानी गिरा हुआ था। तो गलती से मेरा थर्मोकोल के ऊपर रखा गया पैर। मैं सोचा, और मेरे छत पे टाइल लगी हुई है, पूरी पूरी टाइल्स है, चिकनी है पूरा। और मेरा थर्मोकोल पे जैसे ही पैर रखा है, एड़ी एकदम स्किड किया इतना स्पीड से कि मतलब 0.01 सेकेंड भी मेरे पास टाइम नहीं था। मैं बिल्कुल स्ट्रेट गिरा, एकदम धड़ाम से गिरा। लेकिन आधे रास्ते, आधे जितने तेज से गिरा ना, मैं तुरंत बॉडी मेरा टर्न ले लिया ऐसे। सारा बॉडी का लैब ये है, 12 अगस्त की बात है इसी साल, पूरा यहाँ पे सारा लोड हमने यहाँ ले लिया। माई बॉडी रिफ्लेक्स एक्शन वॉज 100% एक्यूरेट। अदरवाइज मेरा पूरा बैकबोन का जो है ना, रिब्स, ये हमारा जो वर्टिब्राज है, ये हमारा सारा बैक डैमेज हो जाता है। जो हमारा रीढ़ की हड्डी, ये सारी डैमेज हो जाती है। उस दिन इतनी तेज गिरा था मैं, आज तक जिंदगी में मैंने देखा भी नहीं ना किसी, मैं खुद भी नहीं कभी गिरा। तो मैं तुरंत बॉडी रिफ्लेक्स एक्शन तुरंत, क्योंकि मैं डेली योगा करता हूँ, एक दिन भी मिस नहीं करता हूँ, 365 डेज, और डेली मैं बॉडी वार्म अप एक्टिव। तो ये सारा लोड यहाँ ले लिया। तो उसके बाद मुझे 10 दिन तक दर्द भी रहा। मैंने दिखाया था किसी को, ऑर्थोपेडिक, वो बोला कि आपको कुछ भी नहीं हुआ, आपका रिफ्लेक्स एक्शन 100% था, इसलिए आप बच गए। तो ये मत सोचिएगा योगा से हम बीमारी को ठीक कर रहे हैं, हम आने वाली बीमारियों को भी रोकते हैं योगा से, जो कि मेरे साथ हुआ था। तो स्पाइन, बिकॉज माइंड का प्रोसेसिंग में टाइम लगता है, माइंड उतना टाइम लगाने मतलब लगाएगा तब तक तो हमारा हड्डी टूट चुका होगा। तो हमारा स्पाइन का जो एक्शन है ना, रिफ्लेक्स एक्शन, बहुत एक्टिव होता है वो, जो अभी मिस्टर राजीव कुमार ने, मंगला ने बताया। तो इसलिए हम लोग को हमेशा एक्टिव रहना चाहिए। वी शुड डू योगा, यू शुड डू सम एक्सरसाइज, वॉकअप, जो अपना मॉर्निंग वॉक, इवनिंग वॉक, जो भी है। बट योगा का सब्स्टिट्यूट वॉकिंग वगैरह नहीं है, ये ध्यान रखिएगा। योगा में क्या होता है ना, हम लोग एक पर्टिकुलर पोस्चर में आके स्टेबल हो जाते हैं, तो हमारा पूरा बॉडी उस पे, उसका पूरा जो इफेक्ट है उस पोस्चर में रुकने के बाद ही होता है, जो वॉकिंग से नहीं हो सकता। जब हम स्ट्रेस देते हैं ताड़ासन में, तो जब तक हम रोकते हैं ना, पूरे बॉडी में हमारा स्ट्रेच आ रहा होता है, जो कि हम योगा करते समय नहीं आ सकता। ठीक है, आई विल शेयर ऑल दिस थिंग्स एंड वी विल ऑल्सो लिंक फॉर द डेली योगा। अभी थोड़ा मेरा प्लानिंग चल रहा है, इसलिए मैंने आपसे एडवांस में ही आपसे डिटेल मांग लिया। बाकी केस लॉस तो आप लोग सेशन अटेंड करते ही रहते हैं, ये सब तो होते ही रहता है। ये चीज हम सोचे आज नया चीज है आप लोग के लिए, बहुत से लोग को नहीं पता है, इसलिए मैंने सोचा आपसे शेयर कर लें। ठीक है,
घड़ी वाली बात तो बहुत अल्टीमेट है।
क्या बोले सर?
घड़ी वाली बात तो बहुत अल्टीमेट है।
घड़ी वाली है ना? हाँ, तब अभी मैं घड़ी का वो शेयर करता हूँ, आप लोग स्क्रीनशॉट ले लीजिएगा, बच्चों को दिखाइएगा।
सर हाँ
एक,
शेयर कर दीजिए सर।
हाँ,
दीजिए सर, स्क्रीनशॉट शेयर कर दीजिए।
आप इसकी फाइल नहीं शेयर कर सकते?
1 मिनट
जो
सर,
आपकी पीपीटी है।
पीपीटी मैंने क्या ना, वो बहुत सर्च किया, बहुत मेहनत किया मैंने, और उसके बाद मैंने ना वो स्क्रीनशॉट को मैंने लिखा, वो पीपीटी नहीं है, स्क्रीनशॉट लिया हुआ मेरा भी। 1 सेकंड, योगा स्लीप डिसऑर्डर सर्केडियम पिक्स। 1 सेकंड, इसको थोड़ा सा छोटा कर देते हैं। 1 सेकंड, 1 सेकंड, थोड़ा सा, हाँ अब ठीक है।
बिल्कुल ठीक है।
इज दिस ओके? हाँ। एंड देन अनदर क्लॉक, ये इसका जो राइट अप है, 24 आवर साइकिल, सर्केडियम रिदम। ठीक है, तो ये 2 क्लॉक है मेन, बाकी तो सेम है इसका, वो टाइम, सारा वो टाइम लिखा हुआ है, कब कब हमारा ये होता है, सेम है उसी का और जो मेलाटोनिन है ना, उसका भी आप ले लीजिए। मेलाटोनिन हमारा सेक्रेशन कहाँ से होता है? ये यहाँ से होता है, 1 मिनट, हमारा पिट्यूटरी ग्लैंड्स, पीनियल ग्लैंड्स, ये स्टार्ट फ्रॉम 9 PM टू एंड एंडेड एट 7:30 AM। अपना सिटी का नाम भी लिख देते अच्छा रहता। अच्छा, पुणे लिख दिया आपने, संजीव कुमार जी ने। Now I take another case. So we have discussed MOU and all the timely implementation of resolution plan is important. We have also discussed content हो गया, counter claim in balance sheet. हाँ, counter claim in balance sheet. See, in this case, what happened? Jet Airways नहीं, ये नहीं है। यूनिलैटरल एंट्रीज इन द फाइनेंशियल रिकॉर्ड्स बाय द सीडी। जब आप क्लेम एडमिट वगैरह करते हैं तब भी इस बात को ध्यान में रखना पड़ेगा। हाँ, यहाँ पे एडमिशन की बात आ रही है, एडमिशन अंडर सेक्शन 7 ऑफ दिस आईबीसी। यूनिलैटरल एंट्रीज इन फाइनेंशियल रिकॉर्ड्स बाय द सीडी टू मेक काउंटर क्लेम कैन नॉट बी कंसिडर्ड। See, unilateral entries made in the financial record by CD to make cannot be considered. In this case, an appeal was filed against the decision of the NCLT in which the petition of section 7 was dismissed. इसका पूरा डिटेल अभी हमने कलेक्ट नहीं किया, बस हेड नोट ये है कि अगर मान लेते हैं कोई क्लेम है, हमने मान ले, एक सेकंड इसको हम रोकते हैं। इफ देयर इज सम क्लेम, सपोज से 1 करोड़ का क्लेम है थर्ड पार्टी का, एंड वी जनरेटेड सम फेक बिल और सम, वी ऑल्सो रेज सम काउंटर क्लेम से 1.5 करोड़। द क्लेम अमाउंट इज 1 करोड़। यूजुअली इट हैपेंस इन आर्बिट्रेशन एंड इन मनी सूट ऑल्सो। क्लेम अमाउंट ऑफ द अदर पार्टी इज 1 करोड़, वी रेज्ड काउंटर क्लेम 1.5 करोड़, but there is no acknowledgement of the debt in the opposite side, from the opposite side, or it is not showing any record. It is just simply we created a counter claim in the balance sheet. It will not work. It is not admissible. It will not work in the eyes before the court unless there is a proof that debts counter claim amount actually occurred, actually admitted by the other side. So on this basis, the section 7 application was dismissed. Now come to section 138, चेक बाउंसिंग। अगर आपने सपोज सीआरपी कर लिया है और रिजर्वेशन प्लान इंप्लीमेंट हो गया है, स्टिल 138 केस इज गोइंग ऑन, है ना? तो उसमें क्या होता है, पर्सनल लाइबिलिटी अंडर सेक्शन 138 एनआई रिमेन्स डिस्पाइट insignificant. Himachal High Court has held that, clarified that personal liability under section 138 of NI Act to apply even when the insolvency proceedings are initiated under IBC. Justice so-and-so decisively stated that the insolvency proceeding do not absolve an individual from criminal prosecution under NI Act for dishonor of checks. It sues in commercial litigation. The petitioner to so challenge the criminal proceeding against initiated against one that is arguing the insolvency placed before moratorium has on such proceedings. The respondent, in this case State Bank, opposed this argument, asserting that the protection provided under by the IBC were only for the corporate entity and did not shield individual from criminal liability for dishonor of checks. There are some judgments also. ये अभी कब का है, ये रिसेंट है, इससे पहले भी हुआ है 2-3 जजमेंट अर्लियर इट आल्सो कम्स, जिसमें है कि 138 the shelter of moratorium can be taken by the CD only, not by the suspended management. So criminal proceeding, criminal complaints will continue against the suspended management in case of check bouncing. This is very important. Lease deed. During the CRP, the lessor cancelled the lease deed. एक सेकंड यहां पे आपको दिखाते property landlord occupied, right to payment. A creditor cannot file restoration application to, just a moment, 16. Insolvency application merely because of यहाँ नहीं distinction review petition. एक second. Yes. Is the recovery of property by the oh just a moment. Is the recovery of property by the owner, land oblique landlord occupied by the CD permissible during the period of moratorium? ये इशू बहुत लोगों के पास आता होगा. ड्यूरिंग द सीआरपी कई बार लीज होल्ड प्रॉपर्टी होती है इसके सीडी के पास. देन we may face such kind of situation. Honorable NCLT Mumbai bench held that legislative intent of moratorium is obviously to keep CD assets together during the resolution process and to ensure that CD continues as a going concern. Any unilateral termination of lease deed during the moratorium period militates against the goal of keeping the CD as going concern. Even otherwise, possession of premises which is being used to keep the CD as going concern cannot be disturbed in the light of moratorium. तो इसमें ये है कि मतलब मोरेटोरियम है और फिर वो ऑनर बोलेगी नहीं आई एम द ऑनर ऑफ द प्रॉपर्टी, प्लीज वैकेट द प्रॉपर्टी, आई वांट, इट इज नॉट पॉसिबल. वी कैन refrain from we can refrain the owner from taking possession of the property by invoking sections 14, by invoking section 65 section 5 read with section 14. ठीक है. कई बार ये इश्यूज आता है, लीज होल्ड प्रॉपर्टी होती है बट पता नहीं होता है. This is also very important. Development right. I'm just touching the head notes because पूरा facts किसी को याद होता नहीं है. Yes, development rights constitute property under section 3 subsection 27 of the IBC can be included in information memorandum by IRP under section 29 of the code. NCLT also affirmed that development rights are property within the meaning of section 3 subsection 27. What is this? 3 subsection 27. Property includes money, goods, actionable claim, land, and every description of the property situated in India and or outside India, and every description of interest including present or future or vested or contingent interest arising out of or incidental to property. So here we are falling in the category of including present or future or vested or contingent interest. So any interest in the property. So development right is the interest in the property. So it is the property. That's why it comes under the definition of property under section 3 subsection 27 of the IBC. The tribunal further observed that AA has jurisdiction to entertain into as to whether the property included in the IM is assets of the CD under section 60 of the IBC, and for decision of the question, the parties are not required to be relegated to the competent civil court having jurisdiction. So development right will be treated as assets of the CD. It should be included in the IM. Simple. Now come to acknowledgement of debts हो गया, लीज का हो गया 138, timely implementation of resolution plan. MOU is an agreement. Raman Ispat judgments. Paschimachal Vidyut Vitran Nigam Limited. You must have heard the name of this case. ये हाईलाइट हुआ था उसका आपका रेनबो के बाद. We will touch only operative part of the judgment. What is the appeal? The party entered into an agreement that is the supply of electricity, PV and see, here the issue was related with the whether this supplier of this electricity is a secured creditor or unsecured creditor. One 230 is overridden of the despite of the two specific provisions. 53. In view of the above discussion, it is held that the reliance of rainbow papers is of no avail to the appellant in this court's view that the judgment has to be confined to the facts of the case alone. See, rainbow को क्या हो गया था, सब लोगों ने एक मतलब it was taking as a कि it will be applied in all cases. Once it is a government dues, it becomes secured creditor. No. In this case, it was clarified. The rainbow judgment was confined to the particular case only, particular facts. Now, effect of Section 77 of the Companies Act. Lastly, the liquidator had urged without registration of charge. The same was unenforceable under the liquidation. The charge was not registered. So, they cannot be treated as secured creditor. Duty of the 78 enacts that the companies whose property subject to charge fails to register, the charge holder can seek the registration under section 3 subsection 31 of the IBC defines security interest in the widest terms. In this court opinion, the liquidator cannot urge these aspects at this stage because of the concurrent findings of the NCLT and NCLAT that PVL is secured creditors. The courts further shows that after NCLT passed the order, the appellant preferred its claim on 10th April 18. Based on that application, the liquidator had filed an application before the NCLT for modification of its order dated 28th August 2018 and contended that PVNL also came under the definition of secured operation creditor in realization of its dues in the liquidation proceeding as per law. The application sought amendment of the list of the stakeholders. The application was allowed. In view of these factual developments, this court does not consider it appropriate to rule on the submission of the liquidator vis-a-vis the facts of the non-registration of the charges of the under section 77 of the Companies Act. Conclusion: for the above reason, it is held that appeal deserves to fail. At the same time, the liquidator is directed to decide the claim exercised by PVNL in the manner required by the law. It shall complete the process within 10 weeks. So appeal was dismissed. He was relying upon the judgment of Rainbow because the security interest was not created as per the law. But in the Rainbow judgment, it was held that the security interest has been created by operation of law. So that's why the Gujarat state tax is the secured creditor. But here it is held that no, there was no registered charge, there was no operation of law whereby the debts has become secured. So he cannot be, the PVNL cannot be treated as secured creditors. Now come to, I'll just take one more case. Thereafter I will conclude. Can say just we have taken up all 10 cases. Not wrong. See, I asked one question. Recommendation for appointment of liquidator other than IRP and RP. The IBBI has issued one circular on 18th July 2023 and issued the circular or letter to all adjudicating authority that once the CD goes into liquidation, it is recommendation to NCLT to appoint another person as a liquidator instead IRP or RP. Can somebody throw light on this? Have you faced any such kind of situation कि आप IRP थे और RP थे and somebody else was appointed as liquidator on the basis of IBBI circular?
Actually, there are many such cases where NCLT, acting on this circular, has appointed somebody else as liquidator.
Yes, but I have seen one or two cases in Delhi NCLT. They have ignored this because this is the recommendatory in nature. So it is not binding to the NCLT. So
Otherwise,
what
it
is
can
the
amend the
payout?
law.
Suppose अगर RP COC pass the resolution that RP shall be appointed. RP is hereby appointed as a liquidator with 100% voting. But NCLT goes against the commercial wisdom of COC. Then what is the remedies available to stakeholders? Because COC has become a stakeholder during liquidation. And liquidation order passed by the NCLT and he appointed Mr. Y. X was the RP, Y is the liquidator. So what is remedies available to this is just practical question I'm asking. What is remedies available to the stakeholders? And being an RP, we should also know. We can also guide to the stakeholders because we have grown this baby from 0 to 6 months. So we would also like to become
NCLT.
See, we have
Suppose
liquidator.
the resolution. Sir, 1 minute. Suppose the resolution plan submitted by the RP, approved by COC, but NCLT has rejected just because it is not complying with 32, then NCLT shall change.
No, NCLT
he will not continue it.
That is different. That is different case. In simple case, suppose COC passed the liquidation order, liquidation resolution. See, because resolution plan has not come. No resolution plan has come.
Achha.
And COC passed the resolution for liquidation. And Mr. X is hereby appointed as liquidator, who has already worked as RP. Now NCLT change this RP and appoint somebody else.
So consultation committee can, under regulation 31A11, the amendment that has come. So as per that, now the consultation committee can decide with 66% voting that so and so would be the liquidator.
So is this not
Here continuation also?
Suppose suppose today is 28th December, and NCLT passed the order that uh, Mr. Y is appointed as a liquidator, and on 1st January, stakeholder, or suppose 10th January, when stakeholder committee constituted 10th January or 15th January, stakeholder committee passed the resolution again that Mr. X is hereby appointed as liquidator.
So here is the power given by the statute.
So is it not circumvention of the provisions
No,
order?
actually, the idea of this provision looks like that if the liquidator is not acting properly, maybe in the wisdom of stakeholders committee, so then they should have some tool to replace him. That is the idea.
See,
It is not to circumvent the power of NCLT. It cannot be. And stakeholders committee would not go against the order of NCLT generally.
yes, but here they see entire the process of the liquidation will suffer because the CRP took 9 months. The RP took 9 months in completing all these things. RP is completely aware of the in and out of the CD. Now liquidator will step in as a new member, as a new person. He will understand entire affairs. He will take at least 1 month, 2 months. So 2 months will be wasted. Okay. So in the interest of stakeholders, this decision shall be taken. It is my personal view only. It is not like I'm not going against
No,
the.
that's right. Because ultimately the stakeholders, whatever decision they take, they will have to carry it. They will have to bear with it. So I don't think the stakeholders would take any such decision which goes against them, which is not in the interest of the liquidation.
Naturally, the stakeholders will like that. Suppose a stakeholder pass the resolution with 100% to appoint Mr. X as a liquidator. Thereafter, Mr. Y appointed as liquidator. Then again, stakeholders decide no, we should again bring the same person as a liquidator because we have to save the time. The time, the value of the property get diminishing. So in that case, I think the circular is against the. I'm not. It is my personal view. This against the commercial wisdom of the stakeholders, because commercial wisdom of the stakeholder is paramount during CRP and liquidation as well as held by the Supreme Court. I'm just discussing in the forum.
Yeah, I think that depends upon case to case. If RP is not discharging the duties while in CRP, how can the CEO, I mean, creditors can ask it to continue?
No, RP
Even the
has given the consent. Suppose RP has given the consent to act as a liquidator, then there should not be harm. Unless there is some lapses on the part of RP, unless there is some any misappropriation, something, then I think RP should be changed. Otherwise, in the interest of the stakeholder, in the interest of all other, like the RP should continue as a liquidator, because the main intent of the code is the paramount of the commercial wisdom is the paramount of COC and stakeholders.
नहीं अजय जी
stakeholders and
There are two
COC,
parts
the
of it.
constitution of both are not the
अजीम,
same.
क्या हाल है?
सर बिल्कुल ठीक है एक सिचुएशन और भी है अजय जी कि
हाँ
जैसा कि सर ने बोला कि आरपी इट डज नॉट फंक्शन अब
हाँ
प्री मैच्योर लिक्विडेशन के केस में आरपी क्या ही काम करेगा पहली सीओसी के बाद अगर सीओसी प्री मैच्योर डिसीजन ले लेती है और वहां रेजोल्यूशन पास कर दिया आईआरपी को या आरपी को लिक्विडेटर का और एनसीएलटी लिक्विडेशन के टाइम पे चेंज कर दिया जस्ट रिलाइंग अपॉन दैट सर्कुलर
हाँ हाँ
दैट इज आल्सो नॉट गुड
नहीं वो ठीक है, अगर मतलब इमीडिएटली अगर चेंज कर दिया, हाँ ये भी सिचुएशन, तो डिपेंड्स अपॉन सिचुएशन, दैट्स व्हाई.
डेफिनेटली पर इट इज नॉट गुड ना
Fact
अल्टीमेटली
of the
हुआ क्या
case.
कि वो मैटर फिर चला गया आपका एनक्लेट के अंदर वहां से डायरेक्शन वापस होकर एनसीएलटी को आता है तो in this circumstances also NCLT should first take a decision outrightly. They should not change the IRP or the RP if recommended by the COC for appointment as a liquidator with 100% voting right.
Yes. So this is our personal
Even
observation. There is no,
sir,
there is
even
no. We are not giving our opinion against the any decision of the IBBI or circular. This is just we are discussing that
Yes.
the purpose of the IBC is to maximize the value of the CD. So how value
Sir,
will
in the
if liquidation complete within the timeline? If
अजय जी,
complete within the timeline.
यस अजय जी, आईबीबीआई के सर्कुलर का बेसिकली ऑब्जेक्टिव ये था कि जहां पे सीआईआरपी को मतलब चलते हुए 2 साल 3 साल हो गए और
हाँ
उसके बाद भी कंपनी का रेजोल्यूशन नहीं आता है,
हाँ
in that case
हाँ
it can be
बिल्कुल ठीक है,
concluded
उस
that
समय वो भी
IRP or the RP should be replaced, then liquidator should be a person other than the IRP or the RP.
एग्जैक्टली करेक्ट
But
करेक्ट। बट ये सब केस में इंप्लीमेंट नहीं होना चाहिए, ऐसा मेरा पर्सनल व्यू है कि सब
I
इट्स,
totally agree with you.
इसीलिए आईबीबीआई ने इसको रिकमेंडरी ट्री किया, बट समटाइम्स बेंच हैज टेकन एज ए दिस शुड नॉट बी द केस। ठीक है,
and
चलिए
one more thing, sir. One more
हाँ
thing, why NCLT must be taking the COC, the members of COC and the members of SCC are different. COC consists only financial creditors, whereas SCC contains other than financial creditors also.
agreed, but even other the
So,
stakeholders OC and FC both decide no, RP should again come back, then then A should accept and he can be replaced, the
Sir,
RP
एक सिनेरियो और भी है, within 7 days of commencement of liquidation COC will be the SCC within 7 days of commencement of
yes yes
liquidation.
yes yes yes
So SCC will come after 45 days of commencement of liquidation.
correct
But it might be possible that COC may take a decision when new liquidator is calling the meeting of COC, because within 7 days of commencement of liquidation, COC meeting has to be called in order to take a decision with respect to remuneration of liquidator, with respect to appointment, or other conditions are also there where COC has to take a decision till SCC is constituted.
correct correct
So
SCC is
that is also
constituted.
scenario.
Yeah.
SCC sir will come after 45 days. That will take a long time.
So you mean to say that the SCC who is existing on 7th day can pass the resolution for replacement?
Sir, why not? Because if you see within 7 days of appointment, commencement of liquidation, COC has to take certain decisions on the remuneration, way forward has to be done. So there is no bar.
Correct, correct.
If my commercial wisdom has been ignored by some regulator, then obviously again I will pass a resolution for replacement of the liquidator stating that you have ignored my recommendation. So again I am sending back the resolution to you. Please appoint so and so person as a liquidator.
Correct, correct.
Ultimately, you want resolution now. Now
Yes,
I have come after liquidation, I am passing the resolution.
correct.
And that meeting has to be called within 7 days, sir. Immediately
Yes.
after liquidation.
But usually SCC doesn't take such a fast decision in any liquidation.
Please, sir, in some cases, I have seen even COC have challenged that decision of NCLT and they have gone to the NCLAT. So
Okay.
if they can do so, so why they cannot do so in liquidation?
That's why the law is still evolving. IBC
That's why.
every
In
day.
so many cases I have seen, and COC has challenged the decision of adjudicating authority and they have filed the appeal. In some cases, obviously, if I am so fast in filing the appeal, and immediately, obviously, I have a power to change.
Yes, yes. Okay, thank you, Najim ji. Thank you. Thank you, everybody. I am just concluding because I have given time that I will conclude by 5 or 5:10. So time is already now it's 5:11. So thank you, everybody, for participating in this session. And if you have any queries, you can also share. My email is already I have shared. And I will also share something through WhatsApp or through email, some health tips for so that you can maintain your health. हाँ, Anjali ji, sorry, Saurabh ji, are you
Ji,
there?
sir. Yes,
हाँ,
sir, I'm here. We truly appreciate the time and effort you have dedicated to guide us today. Your session has been highly engaged and enlightening. Thank you once again for being with us and enriching this workshop with your expertise. Thank you, sir.
okay, thank you, Saurabh ji, thank you, everybody. मेरा chat box में हम डाल रहे हैं. I'm just giving my contact numbers and email ID in chat box. Okay, thank you everybody.
Thank you so much.
Thank you.
To
Namaskar.
the ICSI person, what is the update for the morning session?
Actually, my team will get back to you, sir.
Sir, the problem is 31st of December is the cutoff for the compliance, and I mean, if this is not clarified herein, it will impact the compliance for the current year, and being the last rolling year, last year in the rolling block, it would be difficult. Otherwise, we can attend the remaining CPRs with other triple IP.
Sir, you don't worry. Our team will look into it, and they will make it all clear. And for the session, we will look for the new speaker. For time remain, you please stay put.
Sir, I understand that thing, but in the morning it was promised that by on second half we'll able to know. The problem is we are left with only 2 working days, and being Sunday tomorrow, I mean there are only 2 working days left, and on 31st, Triple IP ICI is doing a seminar. So again, the problem is if we are not aware today, it would be difficult to enroll there also later on.
Actually, sir, due to this is today's weekend, I couldn't like make any contact with my team. So it is from our side that you aren't able to take the session. Uh, we will make it all make it so like I have to talk with my seniors. Sir, why
You are
don't you
not in
put
a
a
position
mail?
to reply now. Please ensure that you are able to reply by Monday morning itself. Okay.
Okay, sir.
Kindly do it before 31st of this year.
Not even 31st, sir, because other triple IPs will not accept the enrollment after 30th only. So on 30th morning, if we'll not able to know, then we'll be in deep trouble in that case.
Then kindly fixed it tomorrow anytime on Sunday.
Okay, sir. Let me look into it.
Thanks.
You can leave now, madam.
Yes, sir.
Okay.